Welcome to the Business Talk, a global podcast series that features distinguished faculty members and their impactful scholarly contributions. I am Deepak, your host from India. We are delighted to have the distinguished Professor Carlton Larson, Grace Business Talk today as our esteemed guest. Before we get started, I would like to introduce the guest for today's episode. Professor Carlton Larson is a Martin Luther King Jr. Professor in Law at the University of California, Davis, a position that reflects both his scholarly eminence and his enduring commitment to justice and legal excellence. He is a preeminent scholar of American constitutional law and Anglo-American legal history, whose wide-ranging research spans some of the most consequential legal questions of our time, from enemy combatant detention and Second Amendment rights to legacy preferences in public universities and the fascinating question of parents' rights to name their children. He is widely regarded as one of the America's foremost authorities on the law of treason, a distinction reflected in two landmark books, On Treason, A Citizen's Guide to the Law, and The Trials of Allegiance, Treason, Juries, and the American Revolution, published by Oxford University Press. Professor Larson's scholarship carries remarkable reach, cited by numerous federal and state courts and featured in leading publications including the New York Times, The Economist, and The Time, among others. He is a trusted voice in national media on constitutional law matters. A graduate of Harvard University and Yale Law School, where he served as an articles editor of the Yale Law Journal and executive editor of the Yale Journal of Law and the Humanities. Professor Larson brought early career experiences as a law clerk to Judge Michael Daly Hawkins on the Ninth Circuit and as a commercial litigator at the prestigious firm Covington and Burling in Washington, D.C., before joining the UC Davis School of Law as a faculty. In today's episode, we are privileged to sit down with Professor Carlton Larson as he takes us deep into the heart of his compelling new book, One Nation Under Law, The Meaning of the Declaration of Independence, unpacking the ideas that continue to shape the very foundation of American law and identity. Let's not keep you waiting. Please join me in welcoming Professor Carlton Larson to the conversation. Professor Larson, your gracious acceptance of our invitation means a great deal to us, and it is with immense honor and delight to be welcome you on Business Talk.
Thank you. Very happy to be here.
Thank you. Professor, your book makes a bold claim that the Declaration of Independence announced the birth of one American nation, not 13 separate ones. What is the most compelling piece of evidence that convinces you of this? And why has this truth remained hidden in plain sight for so long?
So this is one of the major claims of the book, that when the Declaration of Independence was adopted on July 4, 1776, it created one nation, the United States of America, that with respect to the rest of the world stood as one nation, not as 13 completely independent nations. And that's a view that I think in many ways most Americans would share. If you asked most Americans when is our national birthday, they would say July 4, 1776. But of course, much of the scholarly commentary is much more skeptical of that. And so you see a number of people who've asserted the so-called 13 independent nations view. Now, my book goes through a variety of pieces of evidence, the text of the Declaration, the history surrounding its adoption and what happened afterwards, as well as later sort of celebrations and commemorations of the Declaration of Independence. But if you want the piece of evidence just right off the top of the bat, you look at the very first sentence of the Declaration of Independence, which says, when in the course of human events becomes necessary for one people to separate themselves from another. And the term people here in the late 18th century had very much a political sense. It meant the members of a particular political community. And so when the Declaration is saying we are one people, that is a declaration really of national unity. If we're 13 separate nations, it should have said one, some peoples, but it doesn't. It says one people. And so when, for example, in 1707, with the Act of Union between England and Scotland, there were repeated references to the fact that that act made the people of England and Scotland one people. And so one people very much has a political sense. And it's sort of easy to overlook that, but it's there right in the very first sentence.
Professor states rights advocates have long used the declaration to support the idea of 13 sovereign independent nations. How do you respond to scholars like Dr. Gary Wills who hold that view? And where do you believe their interpretation fundamentally breaks down?
Yeah, so this is we Gary Wills wrote a very prominent book called Inventing America, where he insists that the Declaration created 13 separate nations, not one nation. We see this actually in a recent U.S. Supreme Court opinion, where the U.S. Supreme Court has suggested the same thing, that there were 13 completely separate nations, and that that Virginia and Massachusetts in, say, 1776 were no different than France and Spain. So these are completely separate countries, and it's only later, maybe with the Articles of Confederation, or more probably with the Constitution, that those 13 independent nations came together and formed one country. That's the argument that a lot of people have made. And I just think that argument completely falls apart when you look at what actually happened. I mean, you can read the Declaration that way. That's one way you could possibly read the text. But when you say, okay, well then did the colonies and then the states treat each other as independent nations? And the answer is pretty clearly that they didn't. They were called the United Colonies prior to the Declaration. The United Colonies didn't dissolve. The Declaration of Independence was not a dissolution of a union. It was a continuation of a union. It announced that the United Colonies were now free and independent states, so the United Colonies as an entity. They continued to govern the nation as a nation. So through the Second Continental Congress in Philadelphia, they did all the things we would expect a nation to do. They coordinated all foreign policy. They coordinated all matters of war and peace. They presented themselves to the world as a nation, and they repeatedly insisted that they were a nation, and that any attempt, say, for a European country to treat with one state individually was inappropriate. And so in all of those ways, the actual conduct doesn't look anything like you would expect 13 independent nations to look like. And so I think that evidence is really quite telling. And you also have, for example, in 1779, 2 years before the Articles of Confederation are actually adopted, the Continental Congress insists that the colonies are as legally confederated as it is possible to be, that this is an entity called the United States of America, and that it has a legal corporate existence as a nation.
Professor, you argue that the United States initially operated under an unwritten constitution, a concept more familiar from English practice. How did that unwritten constitutional framework actually function, and what does it reveal about the founders' vision of governance?
Yeah, so this is something where I think because America's had a written constitution for so long, we tend to think of constitutions as written. And so we're typically told that the United States of America has had two constitutions, the Articles of Confederation and then the Constitution from 1787. But that's really not right. I mean, it's right in the sense that we had two written constitutions, but it's not right in the sense that we've only had two constitutions, because we existed as a country from 1776 to 1781 without an Articles of Confederation. And so the question is, well, what was that? Well, it was a constitution with a small c, in the sense of this is how the government is put together and constituted. It's not written down in a formal document. But that would have been entirely natural to Americans in 1776, because that's what the English Constitution was. It was essentially practices and precedents accumulated over time, but there's no one document that sets it all out. So you can't go read, even to this day, you can't go read the English Constitution. And so that was entirely familiar to them. One of the signers of the Declaration of Independence, Thomas McCain, says, yes, of course there was a Constitution. It rested on popular consent. So long as the government was operating as it was under popular consent, it was a real constituted government, even though there wasn't actually a written constitution. So I think it's important to understand that we had that 5-year period of an unwritten constitution before we adopted a formal document. But it doesn't mean that the Confederation was created by the Articles of Confederation. It simply confirmed it. It gave it a more precise legal form, but there was a confederation in place from the very beginning.
Professor, one of the book's most striking revelation is that the Declaration is not simply an ode to limited government, but actually a demand for more and better law. Can you walk us through the charges against King George III that led you to this interpretation?
Yeah, sure. So a lot of people who've sort of written about the Declaration, they look at the very beginning of the document, which says government exists to protect life, liberty, and the pursuit of happiness, and when the government becomes destructive of those ends, you should overthrow it. And all that is true, I think. But what a lot of people is going to sort of stop there and say, well, all that means that the government is supposed to do is protect human liberty in certain ways, and that it should really do as little as possible. That is, the framers thought we should have a minimalist night watchman state. The government is largely the enemy. We should be suspicious of anything the government does. It should only be done in the extreme circumstances to maintain just sort of a barely functional society. That's the vision of the Declaration of Independence. And I really think that is wrong. You can certainly read the opening that way, but when you read the rest of the document and put the whole thing in context, what you see is something quite different. And so I think some of the most telling evidence is the complaints and charges against the king. What had the king done that justified this revolution? So the very first complaint about the king is this. He has refused his assent to laws, the most wholesome and necessary for the public good. That is, the king had vetoed colonial laws that they thought were helpful and important. So the claim is not that there's too much law, but there's too little law. And they refer to laws not as evils or necessary evils, but as wholesome and necessary for the public good. And that phrase public good is in there, that's the purpose of law. And so they want more law, not less. And then the very next charge is this. He has forbidden his governors to pass laws of immediate and pressing importance. Laws that we need, immediate and pressing importance. He has not allowed his government governors to do those. Third charge, he has refused to pass other laws for the accommodation of large districts of people. So again, they want more laws. Fifth charge, he has dissolved representative houses repeatedly. And then he has failed to cause representative houses to be elected. We want legislatures. We don't want them dissolved. Then he's charged with obstructing the laws for naturalization of foreigners. So he's interfering with laws that should be there. He refused his assent to laws for establishing judiciary powers. So all of these are complaints about not enough law, about abdicating government, that the king has not provided the competent, functional government that ought to be there. And so when the Declaration is passed, John Adams says this will encourage basically a new spirit of vigor in government to do the things that we need and that we want. And so I think there's really no reason to think of the drafters of the Declaration as reflexively opposed to governmental action. If anything, they view governmental action as something that's necessary, required, appropriate, and that when governments that fail to provide good law are just as bad as governments that provide terrible law.
Professor, libertarians often cite the Declaration as evidence that the founders viewed government as a necessary evil. How does your reading of the text challenge that narrative? And what does the Declaration actually say about constitutionalism and active governance?
Yeah, I think that's the one we just did.
Okay, sure. Yeah. Professor, you revealed that the parchment text enriched in the National Archive is not the correct text of the Declaration. That is a remarkable claim. What is the true authoritative text, and why does this distinction matter legally and historically?
Yeah, so if you've been to Washington, D.C., you can go to the National Archives, and you will see in this central shrine, this large rotunda, what's called the Declaration of Independence. And this is a parchment copy that was signed by many of the people, not all, but many of the people who voted for the Declaration of Independence. And this is the document that is reproduced. You can buy in the gift shop, your own little parchment copy of this, and everybody tends to think of this as the actual Declaration of Independence. But if you ask the question, okay, looking at that piece of parchment, where was it on July 4, 1776? And the answer is almost certainly it was not anywhere near Independence Hall. It was not in the assembly room. It was probably in the shop of a Philadelphia bookseller. It's indeed possible that it was actually part of a live sheep and was only going to be made into parchment soon thereafter. The parchment that was signed was commissioned in mid-July of 1776, so several weeks after the document was adopted. It was then transcribed by a man named Timothy Matlack, who wrote it out. And then members of the Congress signed it starting in August 1776. Some of them continued to sign. New members continued to sign even into November 1776. And it's possible that one signature was added even several years after that. And I call this document the ceremonial parchment because it's essentially it's a formal record of the document, who signed it, but it was done entirely for ceremonial purposes because independence had already been declared. And so if you want the actual text of the Declaration of Independence, we need to know, well, what was issued on July 4, 1776. And that's the document that was printed by Philadelphia printer John Dunlap the night of July 4, 1776, under the supervision of the Continental Congress. There are multiple surviving copies of that broadside. That was then used in various newspapers that reprinted it around the country. And every single person in the United States, other than maybe a few people in Congress, if you ask them what is the text of the Declaration, they would have said that was the text. And it matters because the text is quite different. The Dunlap broadside doesn't include the names of any signatories. It has a different caption. It has different capitalization. And a lot of people have made a lot about the capitalization. They say if you look at the parchment copy, it refers to the United States of America, but with the U uncapitalized, lowercase u. And they said, well, that tells you something meaningful because it only meant the states were sort of temporarily united, but they weren't a legal entity called the United States. If it was truly the United States of America, that U should have been capitalized. Now, there's a very, very many problems with that argument. The first one is, if you actually look at the rest of the parchment, it is entirely inconsistent with capitalization. The guy who wrote it didn't seem to have any formal process at all. He randomly capitalizes nouns, adjectives. It makes absolutely no sense. You can't draw any conclusions from that document whatsoever. Moreover, when you actually look at the Dunlap broadside, it doesn't have an uncapitalized U. It doesn't distinguish the U from S or A. And when you look at all the reprintings of it in various newspapers, you don't see a single one that has an uncapitalized U either. They do it either with all caps or small caps or sometimes just with capital U, capital S, capital A. And so this notion that the Declaration of Independence says it's a small u, United States of America, no one in 1776 would have had any idea what that claim meant. They would have said, you're crazy, because my copy doesn't show that. And yet that myth has persisted because we've celebrated this parchment. Now, if that parchment had been destroyed in a fire in late 1776, no one would even know it existed or care. But we wouldn't think we'd lost the Declaration of Independence, that we don't have its text. Of course we do. We have the text that was actually issued on July 4th. And I think that's the one that we should celebrate. That's the one we should treat as the official text. The one in the archives is interesting. It's a historical artifact. I believe it's really cool that all these people signed it. But we shouldn't be treating it as the official text of the Declaration.
Thomas Jefferson is almost universally credited as the author of the Declaration. Yet, you argue it was authored by the Continental Congress in the voice of the American people. How do you make that case, and what does it change about how we understand the document?
Yeah, so Jefferson on his tombstone claimed that he was the author of the Declaration of Independence. If you take the American citizenship test, they ask you the question, who wrote the Declaration of Independence? There's only one answer, Thomas Jefferson. But I think that's not the right way to think about it. Jefferson, of course, drafted the Declaration of Independence. He wrote the first draft, but he worked as part of a committee of five, and that committee of five edited his document. Then it went to the Continental Congress as a whole, was edited much further. About a quarter of it was cut out, and there were various changes made to it. And that's entirely appropriate because who was ultimately authoring the document was not Thomas Jefferson, it was the Continental Congress, right? Jefferson didn't declare independence, the Continental Congress did. And so it's very clear that this was a document issued by a group, and they had one particular person who helped draft it. That's not really authorship in the way that we would think of it. It's not authorship in the sense of, oh, Jefferson wrote a book, Notes on the State of Virginia, for example, later, or his summary view of the rights of British America. Those are his sort of personal views. But when he drafted the Declaration, he wasn't charged with providing his personal views. Nobody cared what Thomas Jefferson himself thought. He was there to transcribe really what the American people thought and what the Continental Congress thought, and to do so in a way that wasn't novel, that wasn't supposed to make new arguments, but sort of distill the common sense of the subject. And that's what he did, and he did a brilliant job at it. But the problem is when we attribute the Declaration solely to Jefferson, then the question becomes, well, in order to understand the Declaration, we must understand Jefferson. And so if we want to know what a word in the document means, we need to go figure out, maybe Jefferson's personal training, or look at his religious views, or what he thought as a lawyer. And I think none of that is relevant, because what matters is what the Continental Congress thought. Now, if Jefferson's views were shared by everybody, okay, that's great. But if not, then he's just one person out of many who were part of this document. And so one way to think about it is if you think about, say, a statute, say Civil Rights Act, major American statute in 1964, passed by Congress. Do we care, which staffer wrote it, drafted it? And then let's go figure out what that staffer thought about politics or religion or economics or whatever. No, of course we don't care. What matters is the Congress that adopted it, or a law clerk drafting an opinion for a Supreme Court justice, or a speechwriter for a president, right? It's ultimately the person who sort of owns it and takes charge of it who is considered the author. And so I think we really need to think about the Declaration as it's authored by the Continental Congress, and it's done in the voice of the American people. And so the thing is written, right? We hold these truths to be self-evident, right? Not I, Thomas Jefferson, hold this truth to be self-evident, but we. And that we is the American people speaking through the American Congress. And we should certainly credit Jefferson as the drafter of the document, but to just simply say he's the author in the same way you might say, that Shakespeare wrote Hamlet, right? It's just not the same sort of thing.
Professor, you describe the Declaration as a legal document of continuing legal significance, even though it is not law in a formal sense. How has it been invoked in courts, and what legal weight should judges and lawyers give it today?
Yeah, so this is a really hard, but I think sort of interesting question, is sort of what is the status of the Declaration as law? And there's two positions that are really sort of quite extreme. So one is the Declaration is absolutely law. It is just as much a part of our law as the Constitution. It's a fundamental law. It's supposedly part of the United States Code, and we should treat it as a completely binding legal document. Then there's another view, which is I think the more common one certainly among judges and lawyers, which is that it's not law at all, that it's a statement of ideals, it doesn't create legally enforceable rights, and if you go to court and your claim is in the Declaration of Independence, well, you're almost certainly going to lose. That's what pro se litigants tend to follow, and they're usually not at all successfully. So I think there's merit in both sides, but I think they both tend to overstate the positions quite a bit. And so I would propose a sort of much more nuanced approach, which is that it's a document, it's a legal document, right? It creates a legal effect, which is independence of the United States. And it's of continuing legal significance in a variety of ways, but it's not necessarily binding law in the way we would think of a statute. And so that we see it in court in a whole bunch of ways. It's for example, it's in many cases it denotes the severance of English common law, so that is no longer governing after July 4, 1776. You see it in cases of early cases of treason. It comes up with respect to citizenship. At what point were you a citizen of the United States? It was used in the 19th century, actually as a condition of admission for states. States had to create constitutions that were consistent with the Declaration of Independence. And probably most typically you see it as a sort of negative constitution, and that's the term I use in the book, which is that we have all these charges against the king that say the king did this, the king did that. Well, those are all very bad things. Well, that tells you something of importance. If it's bad enough to justify independence, it's probably not something we should be adopting into our law right now. And so you see a lot of judicial opinions where, a particular argument has been made, and the response is, well, that was the very thing that justified independence. And so you see a variety of cases that use the Declaration of Independence in that regard. And I think that makes a lot of sense. Now, you also see cases where judges invoke some of the broader language about, liberty, equality, all men are created equal. And those, I think, are much more mixed bag. You see them asserted for every proposition under the sun. Liberty and equality are obviously very contested subjects. People can have very different views as to, say what is equal treatment in a particular circumstance. And I would sort of discourage judges from using that language, because it's very unlikely to change anybody's mind who isn't already there. People see in the Declaration, at least in that language, what they want to see. I call it a sort of a Rorschach test. And so those invocations of the Declaration, I think, should probably be are best left to the politicians and not wielded so much by courts.
Professor, the first appeal from a state court to federal tribunal was reportedly filed on July 4, 1776 itself, the very day of the independence. What does that extraordinary fact tell us about the founders' immediate understanding of national authority over states?
Yeah, so this was something that was I discovered in the course of writing this book. And it's one of those facts that I think on its own completely destroys the 13 independent nations theory. Because if you ask lawyers or legal historians the question, when was the first appeal from a state tribunal to a federal tribunal filed? I think most lawyers would say, well, it must have been sometime in 1789, after the new Constitution created the first federal courts and allowed for federal jurisdiction over state claims. That, in fact, is wrong. The first such appeal was actually filed on the very day of the Declaration of Independence, July 4, 1776. There was an appeal filed from a Pennsylvania state court to the Continental Congress. And it was an admiralty case. This dealt with issues of shipping. This was always an area where having national uniformity was very important. And so the Continental Congress had said, we don't trust states, basically to run admiralty decisions on their own without some degree of federal supervision. And so we are authorizing appeals from state courts to the Continental Congress. And in that case, the Continental Congress reversed the state court decision. Now, did that look like France and Spain? No, it doesn't, right? That looks very much like a federal tribunal superior to a state tribunal. And this continued. They later created a committee to handle these appeals, and then later created the first federal court, the Court of Appeals for cases of capture. And that existed even prior to the Articles of Confederation. So we had a very rudimentary, embryonic federal court system. And when a later case, a state tried to claim that we're not bound by that, the Continental Congress pretty much unanimously said, absolutely not. You are part of this confederation, and as such, you are bound by its rules. And this is a corner of our history. There's an excellent book written about this in the 1970s, but it's not sort of part of our mainstream discourse about constitutional law, because we tend to think of federal jurisdiction as arising just after the U.S. Constitution. But I think it's a very important part of the story, and it's an interesting side note to what was happening on July 4, 1776.
Professor, I'd like to conclude this episode with one last question. At a time when America feels deeply divided over questions of federal power versus state sovereignty, what do you hope readers take away from one nation under law? And do you believe a clear understanding of the Declaration can help heal that divide?
Well, I hope that we can at least get the history right. When the Supreme Court is telling us myths about our nation's founding, sort of stork stories about how we were founded, then you're not going to be very confident in what follows. And when the court tells us that we were 13 nations at one point, that's just simply wrong. And it's important to get that right. Like, we want to know. I think most people, they want to know, where was I born? Who were my parents? What were the circumstances of my birth? And it's equally true for a nation. I think it matters, when we became a nation. Now, obviously, there's going to be all kinds of difficult questions on the balance between federal and state power, and the book certainly doesn't take any position on any of those. And in many cases, I think there are arguments for states. Rights make some sense. We are the United States, right? States are obviously an integral part of the entire constitutional system. But we should at least be approaching those questions from the premise that we have been one nation from the very beginning. And then I think once we get that right, then we can think a little more carefully about what would potentially follow from that.
Professor Larson, this conversation has been nothing short of illuminating. Your ability to bring history, law, and national identity into such sharp focus is a rare gift, and one that our listeners will carry them long after this episode ends. Thank you for your time, your insights, and for reminding us that understanding where we came from is perhaps the most powerful tool we have for understanding who are today. Thank you so much.
Well, thank you very much. We very much enjoyed it.